in there twice, so I put all the changes in one.
Oh, didn't even notice.
But instead of saying value is reported in the inventory, we're now saying report as shown in the inventory.
That's in subsection B.
And I searched for that elsewhere, but did not. I don't think I found the other.
Okay. And that's it.
And then I added all the applicability, so, yeah.
Oh, okay, let's take a look at that. What does it say? Section 3 applies to settlement agreements entered into on or after the effective date, and that is getting court approval. So that applies to cases that are midstream, that have not come to the presentation of a settlement agreement to the court.
And then, basically almost everything else just applies, petition filed on or after the effective date.
Okay.
And then section 9 was something about the lawyer trust account, so that applies to damage stuff to recover.
Okay. All right,
Lane,
Rick.
I'm not proposing a change, but I'm just mentioning something.
Yeah.
On section 9, it talks about putting it in the lawyer trust account.
Yeah.
You know, the only thing I would point out is we recently saw a case where a partner in a firm stole the money out of the trust account.
Oh, no way, no lawyer would do that.
Must be nice with all those unicorns and rainbows.
That's why we have the client security fund, isn't it?
Yeah, but what's the cap on the client security fund?
Is there?
Talking wrongful death proceeds?
Yeah, I know. Amy, what's the cap on the?
I'm not sure what it is, but they work very hard to make sure it's adequately funded.
Isn't it 50?
I don't know.
No, I don't think so.
I'm not in private practice anymore.
The 50 is, that's the PLF, isn't it? 300,000?
But anyway, yeah.
PLF lot.
The PLF is more than that. Isn't it $1 million?
Yeah, it's $750.
No, you gotta pay extra for that.
Yeah, right, $750 or something you pay extra for.
It's 300.
Is it what it is? Okay, yeah. Okay, so are we worried about that?
Well, isn't the practice, this is the correct practice?
It is. Right.
Well, but you know, I'm just here to feed you straight lines.
You are?
If you put it in the estate account, the PR can steal the money.
That's right, and we've seen that too.
Yeah. Okay, point noted, but, section.
I want to make sure that goes in the minute.
All right. Section 10, this is the Steve Heinrich amendment, at least, I don't know, section 10, you've got that effective, to estates in which the petition for the appointment of PR is filed. Is there any reason to not make that change to the attorney fee calculation effective, to affidavits filed after the effective date? Anybody have any heartburn about that? That would be making section 10 sub B effective as to petitions, as to attorney fee affidavits filed after the effective date. Because otherwise, we've got January 1 of 2020 will be the effective date. Then this change would not take effect. Then this change would take effect to estates filed after that date. So you wouldn't see this reflected in the attorney fee affidavits for at least another, for at least a year and a half.
And this is just changing what we've already changed.
Yes,
Yeah,
right.
so I agree with you.
You could almost make that an emergency clause, but the legislature doesn't like emergency clauses. I don't think it's that big a deal. So can we do a separate sub B with its own effective date?
You can, so you basically just amend it twice, so you
Oh.
have to change it.
Right.
Second set of changes would have.
Yes, the rest of it.
Operative date,
Yeah.
yeah. Mhm.
Let's do that. Is everybody okay with that?
So make,
Well,
So that how we've changed the calculation of attorney fees based on the highest value, will take effect
Why would
as
you do that?
to attorney fee affidavits filed after the effective date. So it affects petitions that were already, I mean, estates are already open, but where the affidavit hasn't been filed yet.
Is there any reason not to do that for this whole section?
Well, I don't know, because the rest of it deals with,
PR fees.
I'm sorry, PR fees, yes, that's right, sorry, my mistake.
Yeah, you can't change the reference to a personal injury cause of action.
Right, because those sections aren't effective yet.
Then you refer to something.
Right.
Using Zoom to get the audio.
Make sense?
Yeah.
Okay.
So this one,
I'm on, or email, but then.
oh, how would that be?
Call.
Yes, I can do it.
Petitions filed after passage, or after.
No, it would just be petitions, it would be, petitions filed after the effective date. Or application, yeah, so what are we making it effective to? Requests for attorney,
You can't speak.
Down here, it says upon application to the court, a personal representative is entitled to receive compensation for services provided.
that's true, okay? So make it effective for applications for compensation filed after the effective date?
Well, if you got one pending, you can amend it if it hasn't been granted yet.
I wouldn't.
If you haven't got the estate closed.
You're not gonna see any real amendment. I mean, again, I think this is kind of a unicorn that we're fixing here, really, but,
What is your obsession with unicorns?
You started.
So, effective as
I
to
look for a lot of things,
applications
but never-
filed after the effective date. Okay,
Can I raise one more thing? I got an email from Steve after with the language,
yes,
and he flagged that the phrase material misstated, he was wondering if that is too vague and if there's a better, phrasing. He suggested incorrect or in error.
well, no, because incorrect could be,
10 cents.
yeah,
Okay.
yeah, that's the point, materially misstated is the point.
Okay. I just wanted to
Yeah,
check.
okay, yeah.
I'll tell Steve to get a life, the rest of the world.
Really?
knows what material means.
Yeah, so that is gonna be a judgment call on the court. Sandy, would you make a note for a comment about that, you know, yeah.
Susan is on, by the way.
Oh, Susan, you're on the phone.
She is.
Okay, we'll take that on faith. All right, so I think we're done then with, 2962.
Wait.
Well, okay, wait. Shannon, any last comments from the wrongful death world?
None for me, thank you.
All right.
It was that materially misstated at the time of filing of the document. There are several documents identified ahead of that, so I would think the should be a document.
One of those things.
Yeah.
The highest value is shown in
The,
that or the other thing,
right,
then you're just talking about one document. The document relates to any of those things. Yeah.
Well,
it goes back to the beginning of that sentence as shown in the.
there are
inventory.
multiple of those things, so D can only refer to one thing. And there are multiple things, so which one of them does it refer to?
Well, the value of the asset is the highest correctly stated value is shown in one of the documents.
One of the documents makes sense. Any of the preceding documents make sense, but the document doesn't make sense, because which document is referring to?
Well, to fix that, I would just list them out all again, which is how I had it in the first place, kind of for me.
Trying to save words.
I think it's fine.
I do too. Get a life, John.
I think it's grammatically, it's just grammatically wrong.
I don't think it is, though. I mean, it's.
When you look at it in context.
It's the highest value as shown in A, B, C, or D of these documents, was materially misstated at the time of filing of the document,
And of course it means
because it's
the one in which it
the
was
one
materially
which
misstated.
stated the highest value.
Well, if it was the highest value of an asset as shown in any of the inventory and amended surrender, then the document would work, but it's systematically.
Any inventory, any amended or supplemental inventory? I mean, there's just one inventory.
There is only one
Any-
inventory, yeah.
You mean any of the inventory, any amended or supplemental inventory?
I just think, I mean, I think it's there. I don't think it's susceptible to be misunderstood. So I'm gonna stick with Jennifer's excision of the extra words.
Just as a quick question, that deals with the value of the property changes. One of these things we were talking about originally, there's property and the value changes between the time of the filing and or remember, this is not my practice area, but the time of the filing and the value changes because there's a stock market crash or, they discover it's a brownfield or something like that, and then the value's changed of the property, so then
Well, those are two different things.
Okay.
If it's a
Yeah.
stock market, if it's a stock, it was properly stated and the risk was real,
Mhm.
even if the market declines. If it turns out it was a brownfield, then I think that is a material mistake because it wasn't worth what it was reported. So that's really not a change in the value. I don't think a change in value, we're not talking about a change in value here.
No.
Because otherwise we'd be
Steve's
saying,
original-
otherwise you'd be saying the fee's based on the lowest.
Steve's original complaint about this was that somebody was overly ambitious about the value
Right.
of this property
Right.
in the opening inventory. And then when they actually went to market, found out it sold for half of what they had in the inventory because it was never worth more
Right.
than that. So he thought that should be corrected.
And I think we've corrected that. But
Yeah.
I don't think this is meant to accommodate, to reflect a change in the value of an asset.
so it's not, like, if the market changes, then
You still get to use the highest value because
Yeah.
you are on the hook for that risk. And that's kind of what this is recognizing.
okay, thanks.
Okay, so we're done. 2957.
So this one, the only change is in, section 10, which is starts on the bottom of page 7, and the one I'm looking at, 116.03. And the change is on page 9 in 3, which was about mailing the copy of the statement in lieu of the accounting to creditors. And remember, we were struggling with the notice and the statement. So,
Right.
I cleaned that up the way that we decided, so.
For each financial account, so we're not saying bank account and investment account. It's,
That was before.
That was
We changed
before?
that before.
okay, so what has this done?
This says, within 30 days after the date of the mailing of the statement, the creditor, I think this talked about objections before, and now it talks about notice. So I think, read it and see if it makes sense. That last.
Upon filing of a statement under this subsection, the PR should mail a copy of the statement to each creditor whose claim has not been paid in or allowed within 30 days after the date of mailing of the statement. A creditor entitled to receive the statement under this paragraph may, by a written notice to the PR, require the PR to make and file an account of the PR's administration. There's subsection 1. Okay, so yeah, it's not an objection, it's a notice. And then I guess if the PR doesn't file an accounting, then the creditor would have the right to bring the matter before the court and compel the PR to do it.
That's the only change.
Okay,
And then there's applicability.
okay, let's take a look at the applicability. So it's all effective as to petitions filed on or after the effective date. Yeah, that makes sense. I think so.
So this applies to when?
January 1, 2020. State petitions filed after that date. Yeah, it has to be, because, you
Why
know,
would you not be able to do this
you mean the
if you've got a pending probate?
statement in lieu?
No, if you've
Well,
got,
because it's all pegged on, well, let me see, it's all pegged on the petition stating,
Yeah, this
That there are
petition under
no-
section 5.
yeah, that there are no known assets.
I'm sorry, right,
And statement of the purpose for filing the petition. That's,
oh, I was still on 3A, on 3.
okay,
On the,
So would it be possible to have 3 be effective soon?
yeah,
it would have to be, we'd have to amend it then, amend subsection 1, because it says if the petition states there are no assets.
Oh, well, wait, no, this one is if the distributees consent in writing.
yeah, section 10, sub 3.
Oh, I'm sorry, 10, I look at 9, yeah.
Yeah,
Well, okay, that's,
Because that would be a handy thing to get effective right away,
Okay.
and not have.
Yeah.
all right, sure. So then we'll do the same thing here as we did in the other one. We'll have section 3, and is that the only one then that needs to be made effective earlier? Yeah, okay,
And that also saves the court time.
it does, yeah, right. Well, actually, there's no reason, because the whole section 10, because the other amendment in section 10,
The whole no asset.
it's, the other amendment in section 10 is just the, requirement of an accounting with just the reorganization
yeah,
of
this
sub
whole
1.
thing is all about that.
Yes, so we can do all of section 10 and give it an effective date, so we don't need to amend it twice. Yeah. Okay,
So, 3A is, unless otherwise provided by the order of the court. I know last time we talked about putting in the commentary.
Yep.
That this was not supposed to just be an automatic thing.
yep,
Could we add, would it make sense to add upon good cause shown to the text?
What would that mean, though?
Well,
Do I have to make a specific finding?
especially if no accounting is, your first annual accounting, what's the good cause?
good cause could be, there's a lot of creditors,
The heirs are cats in the sack.
the heirs are contentious. I don't think that that's gonna be a hard thing for the court, but you're gonna have a gut reaction. We're gonna say, no, we need to have a regular hearing, and then you do your reason. But I would like to see them in statute, because, I can see, you know, the probate commissioner being told, okay, can't do a blanket order, but in every one of these, we're gonna not allow it.
Jeff, I want you to channel Judge Tennyson. Because we are walking a kind of a razor-thin compromise ridge here.
We'll put Jeff, when you think.
I think my opinion on this whole section is pretty clear, but,
Still.
but if you're expecting a judge to make findings in a vacuum, essentially, that probably won't happen. When we get these harmless error wills, people think the judge is gonna draft their own findings on these, and that doesn't happen. And then they get upset that they have to go back and draft their own findings. They're trying to admit something that's an exception. Obviously, they're not gonna submit their own findings for the judge to say you have to file an accounting, because that would be shooting in the foot.
Right.
Why do people get upset about having to submit their own findings to the judge? I mean, that's how you get what you want.
If you're asking me to rationalize.
Yeah.
I don't.
Okay, yeah. No, my sense is that we should leave this. When I present this to the committees, I will make a special statement about this section, about the intent that this would not be a standing order or an order entered in every case, but would be based on some particularized information known to the court or made known to the court. We'll have that in the report. And I guess if we see abuse after a couple of years, you know, then we can come back and take a look at amending it based on whatever the history of it shows.
Well, can I beat what you're trying to make a dead horse out of?
Go ahead, we got
So
another.
I file a petition for probate.
Right,
It says, this person's dead.
it's a good start.
Here's the will. Here's the will. Here's the inventory, and there's some assets of, I don't know, whatever you want it to be, 500,000, million, 3 million. And here are the waivers of the annual account signed by all of the distributees. The court has no idea what there is in the nature of claims. The court has no idea.
Even on the filing of the petition.
Right.
Right.
The court has no idea how contentious the situation is. The court should assume it's not, because all of the people who could be in contention have agreed.
But
How do you?
But that's fine as of the point of filing the petition. If within the course of the year there have been 5 hearings, filed by creditors or by heirs, the court may have may look a little bit differently at those consents.
Well, I agree with that. But I'm just kind of like, on the surface, how do you ever justify ordering annual accountings when all you have is a lily white record? What basis?
So I don't know if that's a valid fear that the courts are gonna do. I mean, verified statements, is there a rash of judges ordering accounting instead of verified statements?
Which is, because you're right, courts can do it, that unless otherwise already is the language now for verified statements, yeah.
Apparently, things are different in other counties.
Yeah, I don't know.
I've never ever seen an order saying you must file the final account.
I guess, John, let me speak up for John. I think the concern here is that this is new. Verified statements are, they've been around forever. Everyone's used to them. Nobody's afraid of them. We've got something here that's kind of a new thing. Courts are going to be unsure about this. Some judges are going to be more unwelcoming of it than others. So I think this is different, probably, just because of where we are. But I still think that I'm, for the purpose of moving this forward with as little trouble as possible, my inclination is to leave the language as is and just make the record clear. And then again, we'll look for a couple of years and see what's happened in the courts and the practice. And if we've got a problem, we can fix it then. I mean, worst scenario is we end up where we are in a couple of counties. That's the worst scenario.
Yeah.
Which isn't the worst thing in the world. And if that is a problem, then we can tailor an amendment to address what's happening in the real world. Okay? All right, so we're done. Section 10 will be effective as to accountings or whatever. Yeah, right.
With regard to the small states, do you just want a clean break on that one where, affidavits filed, then they're going under the new procedure all the way through?
I think so. 88.
Yeah.
So 10 should not be effective as to accountings filed.
No. So after well, yeah, I mean.
Because you're not filing.
Well, I know, yeah, but she'll have to.
Shouldn't it just say
Effective on
January 1st, 2020?
Only make it effective on the date of passage.
Yeah, I think we need to make it clear that that we're not making it, I think we do need to make it clear that this one becomes effective to estates that are in midstream.
Yeah, it'll be, what?
I would, for all the rest of them, we have that it's for petitions filed after
Right.
January 1st, 2020.
Right.
If section 10 becomes effective without language regarding some sort of filing, just becomes effective on January 1st, 2020, then it's the law at that point.
Right.
And-
Yeah, we try to make it a little more clear than
Okay.
that. So could it just?
Estates pending,
Accounting due after the date? The accounting.
or maybe maybe estates filed before the effective date, and then it just,
Yeah, all of it.
that's all you need, that's all you need to say.
Yeah.
But that's an LC thing,
No,
but.
it's not the state's filed. You want it pending the state.
It just applies to everything.
Before the effective date, section 10 becomes effective as to estates that are filed, before.
Before, on, or after.
Before, on or after, yeah, that's it, yeah, that's what I mean. Right, otherwise, it would not be effective after January 1 of
Right.
2020, that's not the
Very
intent.
narrow benefit date.
I think you
Yeah.
need to think about
Follow up with John's statement. This is not, the waiver of the annual accounting is not intended that we have all the heirs sign off at the time the petition is filed and the appointment of personal representative. Or can you
That wasn't my
withdraw
thinking,
that?
but I guess it doesn't say you can't do that.
Well, then if I'm dissatisfied with personal representative.
You revoke your consent.
I revoke my consent or file an objection?
Yeah.
Okay. Just so we're clarifying
Yeah,
that.
good point. Yeah, I think if a beneficiary or an heir consents and then has second thoughts about it, and they just notify the court that I withdraw my consent, and I think at that point you don't have the consent of all the beneficiaries.
John's gonna draft irrevocable consent.
Shall be binding on me and my heirs.
I don't think you can do that.
Requiring annual accounting.
You gotta remember, we do a lot of plaintiff's work.
All right, so,
Well,
Marissa tells me that we don't have a redraft of 8888, the main small estate, statute, because it was pristine after, last, go-round.
And that will be effective when?
As to estates filed,
Or affidavit.
affidavit, yeah, right, affidavits filed,
After the effective.
after the effective date, yeah. All right, so that takes us back to, good, we have a couple hours,
What affidavit?
small estate affidavits.
Oh, okay.
8888 will be effective as the small estate affidavits filed after.
After the-
So on these three, 8888, 8888, 2957, and 2962, would you send, once you get them revised, send them all out one more time, together?
Well, they'll be delivered to you, so,
No, what I mean even before then, if you, I mean,
oh, sure, well, it'll, when I get them revised. that's
When you
what
get 'em
mean, 'cause
revised, yeah.
Then they're gonna go through editing.
Oh, yeah. When you get them revised, yeah, before that,
Okay, sure.
send them to me, or to Sandy.
Yeah.
Let's circulate them to the work group, and everybody take one last look, and we'll see if we need another meeting to address any comments or issues on those three, but for now, we'll assume that they're good.
What's the date on the current recent version of quadruple A? 1214. I got so many different versions.
I know.
Oh, yeah.
Yeah, and I almost hesitate to add,
Oh, you
Should-
know what, wait, let me make sure that the actual date is on the top.
that's what I've got.
Oh,
I think that's right.
all right,
Yeah. What's the sense, do we want to send these out in draft form, unedited, but with our work to the estate section?
Oh, God.
I know. Let's just let them be surprised.
So, then we have this whole flurry on the list, or what the hell are people like?
I know it, yeah, I mean, that's I guess my concern about sending it out early is because we will get that, we will get plenty of it.
Well, last time we got nothing.
Did we,
I remember we sent something out and we got like nothing. All they wanna do is complain later.
until it passed, yeah.
Yeah.
So just, because I used to be the liaison for the estate planning section, and one of their priorities in the last 18 months has been to do more legislative outreach to their members so that people get, no one's surprised, and you don't get that kind of fuss that I think that you've gotten maybe a few years ago. And so I can say that they have, as an executive committee, prioritized giving early warning and doing more outreach on legislative issues. I'm no longer the estate planning liaison, so I can't speak to what they've talked about recently, but that was a part of the discussion when I was there a year and a half ago.
I'm just picturing a virtual room of 975 lawyers going through these.
Well, in reality, if there were a lot of changes, then what would we do? Withdraw the bill and revise for next session?
No.
Because the timing now.
Yeah, I know.
is
Yeah.
such that
It would only be if there was a unanimous or consensus hue and cry about one thing that pointed an error that, I'll leave it to you all.
There might be some, there might be some error that we're making that,
That's what
Warren
we have.
Harris is the most likely person to catch it.
I mean, they can read the
Because
bill.
he's the
They
only,
can read the bill, that's
he's
right.
anal enough to do it, he'll read it, and he may tell us we got something that's inconsistent with some other section that we didn't notice, and we can fix it real quick.
Well, we'll tell him to read his own damn small state statute.
Well, so another option is sending it to the executive committee,
Yeah, but that's gonna go out.
then they'll go,
Yeah.
Yeah.
Okay.
They did, just on that idea, there was another bill that came from a group, and it was specifically, just this in December, specifically distributed to the executive committee, and they gave feedback, and my understanding is it didn't go out. So that's just information, not an endorsement.
Okay.
You
I'll
know,
wrestle.
it's also, that was December, this is January.
Right.
I mean,
Okay, let's do this. Let's wait until it's edited. And then we can send the LC out before the hearing. Yeah, I think I want that. Okay, let's look at statutory form. Let's talk about this. I missed the discussion, so somebody bring me up to speed. Hint, I've heard. So, let's go back to the discussion about statutory form. All right, hearing no discussion.
I was on the phone, but John was objecting to a statutory form. Did I hear that correctly, John?
Yeah, I just thought it was, I think it's futile that, it's just not going to, it's just not gonna be, no matter how hard we try, it's just not gonna be right the first time. And when it's in the statute, it's gonna have to get modified repeatedly. And as you try to, you try to anticipate all kinds of things in it, and when you actually start using it, you're gonna run into situations where it misses something or it's off the mark. And it's gonna be kind of a thing. So I think, personally, I think it's better to do what we did with the advanced directive, which you create a mechanism for some other group to prepare, to update the forms and prescribe them. Instead of having it in the statute itself, we just delegate it to some group and,
well, actually, the advanced directive statute does have a form in the statute now.
It does.
Default, and then delegate it to a group. And then, once that group reaches consensus, it has to be approved by the legislature. So,
yeah.
I don't think it's gonna be forever if we do that, and so then let's put our form in the default, and then if we wanna have a committee doing this, who's gonna wanna do it?
Yeah, right. We'd have that committee do it. The Committee on Forms.
Well, you got the
Have you
counties,
clamored for that
why
one?
don't the counties, the counties can prescribe their own forms.
They've done that, and they're inconsistent, and they don't comply with the law. One of the things that's missing in all of the forms that I saw was dealing with the sheet to, the state of Oregon. They don't address the sheet.
And I think the inconsistency is the strong argument that if it depends on where you are, what you're filing.
I think consistency is good.
I do
And then
too.
as a practitioner, once we put it in our system as form, it's not a big deal at all,
Yeah, but the other objection, that was just philosophical, my objection to is, I do not want to use this form, period, ever. Never in my life do I ever want to use this form. And as long as I'm required to, I'm going to be unhappy about it. Because it takes too long. It's going to really increase the cost of a small estate affidavit if you have to sit down with a client and go through all these, however many, 13 pages of information. I can create.
Plus the instructions.
Yeah, I can create a small estate affidavit in, you know, probably half an hour of my time and an hour of paralegal time, and it's all done. So I just don't wanna be forced to use this. So if it's optional, that's fine, I don't care about that, but it shouldn't be a prescribed form. This shouldn't be the petition, this shouldn't have to be used.
You know, when, I would, one of the reasons that I think that this form that Jennifer's put together is we've made it clear that these people are fiduciaries. There's responsibilities that you have and personal liabilities that you have in forming these people. And even when they're represented by counsel, the number of times I've had to show cause, and I have the personal representative and the attorney both standing in front of me, and I'm saying, personal representative, you did this, this, and this wrong, and this is in an estate. And they say, well, I didn't know that, my attorney didn't tell me anything like that. And the attorney's jaw drops to the counsel table, that, you know, they're trying to recover from that. I would think that as an attorney, I would want to have my client signing off on all these things, so that if they said, no, I gave the jewelry to my daughter, it's like, wait, here's your initial right here. I would assume you have those kind of checklists, or I'm assuming every attorney has those kind of checklists that they have kind of as a CYA, especially in a small estate, when you file the affidavit and tell your client go out and send no more. I don't know.
Well, I don't mind giving them a piece of paper and say, here, read this, because this is what you're supposed to do. You know, this is your oath of office, so these are your responsibilities. But have a form, especially one where you've got to initial everything, it's gonna take a lot of time to go through that with a client. You gotta do it in person. You gotta discuss every one. It just really increases the cost of what's supposed to be a really simple procedure. And I can understand that when it's being done pro se, that's a different kettle of fish. The more information you give the pro se people, the better it is. But they're not all done pro se. And you're gonna force them all to be pro se, because nobody's gonna wanna pay a couple $1,000 to a lawyer to sit down and go through all this stuff. I want to be able to, I can create a compact form that meets all of the requirements of the statute very easily. And when it's one bank account that we're going to get and transfer over to the living trust, I don't need to school the client on what their theoretical responsibilities are, because we're just going to go get the money out of Wells Fargo Bank and put it into the other Wells Fargo Bank account in the name of the trust. So, you know, you're just causing damage with something this complicated.
So substantial compliance,
I was just gonna say, John, would you be okay then if we had a section at the end of the affidavit, kind of like the John Rough forms, that says, you know, I chose this for myself, I filled it out, and so then if the applicants have done this on their own, they have to go through and initial everything. And we could have a statement that says an attorney prepared this for me, explained it to me, and then they don't have to initial anything?
I just want to prepare the form just like I have in the past.
So,
I want to put only the information that the statute requires.
And that pertains to your
Right, it
estate.
pertains to my situation. I don't want to deal with explaining what testate and intestate is to somebody when I know which one it is. I don't want to talk about heirs and beneficiaries. I don't want to have to explain all these things to people and charge them for it, and I sure don't want to do it for free. And, you know, so it's just a burden on the practice.
let's just say that we were to suggest the idea of saying any lawyer can use their form, this is a pro se form. And then I would think that the 75% of these small states that are filed by pro se.
Sounds like it's more than 75.
Using this form,
Pro se?
whatever the number would be.
It's close to 90%.
Whatever, the 90% of the forms that are filed would become the standard of care. And so if there's some failure for lawyers not using this information for their clients, then there's potential liability. So my practice would be, I'm gonna use this form. And my thought would be, most of the people that I deal with home states, they have big trusts, they've made a mistake, they have a bank account that has to be put in.
It's not always a mistake.
Right, some, yeah, some intentional, and it's gonna take an extra hour of my time. And so, okay, it's gonna cost an extra $300. I'm not worried about that. And to me, what this provides in the benefit for the 90% far exceeds, you know, dealing with those exceptions when you have, you know, a lot of wealthy people that can pay the extra $300.
Here's a practical question. How do we accommodate, you know, in some estates you're gonna have 2 heirs, in some estates you're gonna have 40 heirs. How does that work in a statute? Do we have, you know, attached schedules? Because this one doesn't, you know, I mean, and also, the same thing with beneficiaries under the will. And property, you know, the form provides so much room. I'm just thinking of a printed form. If this was a fillable PDF or something, that works well, because you can just, you can expand the form to fill the space. But if you know, what do you do when you got a printed form and more information, either in the way of heirs, devisees, or assets, then you have room to fill in the printed form?
So they have that now. How do they deal with it in the forms that you guys see?
They attach another sheet.
Yeah.
Yeah. And I could put that in the instructions if it's not already there. If there's insufficient space attached.
I think you'd have to,
Yeah.
because you've only got, if it's printed, it's only gonna have so much room, and it's, it won't be enough for at least some. Well,
You limit it to the 90%, I don't care. Just, you know, but then you got the other problem, like I submit an affidavit, I submit a small estate affidavit that complies with every requirement of the statute, but it's not in this form. And the form has requirements that are not in the statute. So why would we have?
well, if to use the form, we'll have to go back and make amendments to 8888.
Well, I think I
Yeah.
identified in the form the places where we would need to
Uh-huh.
do this. Because when I was writing this form,
Right.
every place I was looking at the statute.
Right.
And there were a couple of places on page 8, you notice creditors, if we were gonna require them to send a copy of the death certificate, I think we changed that to if they ask for it, that kind of change would have to be made. And there was, on page 9, where we're talking about affiant duties, this was again about providing a death certificate to a potential creditor. The statutes don't say anywhere that the person has to file required tax returns, so that on page 10 would have to be added. But I really did make an effort to follow the statute, and if I didn't, to identify that on page 12. You know, it's not clearly stated anywhere that the applicant is personally answerable to the heirs or the devisees, but that's implied. So I, you know, I mean, I recognize that when you're doing this kind of form, it's got to follow the statute. So I was very cognizant of that when I was drafting. Statutes don't say you should have certified, but, you know, if you've got an attorney, that really is irrelevant.
How do you, practically speaking, how do you make this form, how would you draft it so that you, the pro se affiants would have to use this form, but affiants who are represented by an attorney don't?
Could you just make it a safe harbor form?
Yeah. And then that's the only form the courts use. I mean, it gets rid of all the other court forms.
Well, but safe harbor, I don't know that safe harbor would work, because if it's safe harbor, then we're not saying you have to use this form, anybody. And then there are things in here that you know, then you don't have compliance.
Well, you'd still have all the statutory requirements for the affidavit, but you could just say this is a form that you may use if you choose to use it.
Or,
And what benefit do you get from that, though? I mean, what's the safe harbor?
yeah,
Well, that's what we do with deeds. We got a statutory warranty deed, so the
Right.
warranty deed may be in this form.
right.
It doesn't have to be.
There is no pro se that's not gonna use the form. They wouldn't have a clue how to do anything without the form, they're gonna use it. They're gonna ask us for it, but they're gonna, they're gonna use it.
Yeah, because it's easier than hiring a lawyer.
If they're not using a lawyer,
Yeah.
they're going to, everybody wants forms in the courthouse, they come to the courthouse. So,
For the annual accounting that we did,
Yeah,
it said this form shall be accepted in every county. Right, but if that was the same kind of pushback, that if you use this form, you can go to any county and they'll accept it.
Yeah.
If you wanna do something else, you're gonna have to take your chance.
I guess the one thing about that, is, for instance, we're requiring them to initial everything on this form.
I have a peeve about that, by the way.
Okay, well, okay, we're requiring them to initial every item on this form. That to me seems to be a pretty strong policy statement, that if we're gonna do it, I think we'd wanna do it in all cases. It seems, that to me is different than the form that, doesn't comport exactly to the statutory form. That initialing is a significant element of the form, and I don't know how you make that, how you require that in some cases, but not in other cases.
it would seem like the legislature would want to treat the clients of an attorney differently.
Right.
Than the pro se.
John, what if we were to eliminate the initialing?
Well, that detracts from the goal.
Well, not necessarily, I mean,
I'd rather see it be as it is, but optional, than to start taking away the protections that they put so much effort in trying to create.
yeah, but again, I just, if we didn't have an element like the initialing, I would say optional, or you say substantially in the following form or something, but the
Mine
initialing,
won't be anywhere close.
huh?
My form will not be anywhere close to this.
Could you take your current form and have the client initial, just go through an initial everything, once you prepare the form, and then you don't have to go over it, and they're signing the
I can't
form.
tell a client here, initial every line.
But you're telling them, you need to read this before you sign it, because you're signing it under penalty of perjury. So why can't you tell them to initial every line if they're gonna sign at the bottom?
To initial every line of what, this form? Because they're gonna
What
wanna know.
your Lane's saying, you can't say, pro se people have to initial and private lawyer people don't. And so what that would mean is, the forms prepared by the lawyers would have to have the initials. And I'm just asking you, if you could do your form however you want it, but have the person initial it, would that be a problem?
Other than it's kind of absurd, no.
Well, but Judge Cobb, I think, really likes the idea of the initials, because it makes it easier for the court to hold these people accountable. And it also hopefully would make them a little more careful in undertaking their fiduciary duties.
Well, when I ran a test with the clerk,
Mhm.
they were saying, because originally you had some check boxes, some, initials, and they were saying, okay, what am I supposed to be looking at? And that's when Jennifer and I gave her that feedback, and that's when we kind of went to the initials, so that if the clerks are looking at it, they're just going straight down, there's initials here, fine, we'll file it, go away. And I think Heather was the one who wanted to.
Yeah, Heather was kind of the initial proponent of the initial.
The initial proponent.
The initial, yeah.
Plus, my clients don't want to screw around with this, and they want to pay me to do it. And, and I'm not cheap, and they, and I charge them, I charge them a reasonable amount, but then I say, well, that's what I'm paying you for. Why do I have to do this?
The lawyer initial it, you could charge.
You're telling them never to.
I'm not mercenary about it. I'm just,
Well, okay, wait, how about, we're just thinking of this. What if we said that if this form is signed, what if we allow a small estate affidavit to be signed by an attorney for an affiant? And if it's signed by the attorney, okay, don't like it, yeah.
To action this affidavit and there'll be a wait.
Right, yeah, the attorney can't.
That's the problem.
You're right,
Yeah, I think what the affidavit from the applicant.
yeah.
For what it's worth, we probably get more small estate affidavits than anybody else in the state. And from our perspective, this would be great because most of them are pro se. And, it's gonna make it easier for us in those cases where we gotta go before the court and say, Your Honor, we got a problem. On the other side of the coin, I would, if this is gonna be mandatory, I am gonna have to ask for at least one change, because as Jennifer and I corresponded about this earlier, where there's a provision for us to nominate affiants, and that was not enumerated in your list, and you said, well, your expectation was that the attorneys we nominate would use their own.
And that would fit right in with the exception for the attorney prepared one that we were talking about for John, right? I agree, there does have to be.
Yeah, I mean, this is great for us because we know where everything's going to be every time we look at this form.
I don't think it's that complicated. I think you just make it optional. And the pro se people are all gonna use it. As you were saying, they're gonna use it because they're not gonna wanna sit and read the statute and try to decipher what they need to do.
They can't.
So they're gonna use the form. As long as all the counties use that same form, then it's gonna happen 90% of the time. And I don't think, as a policy matter, I don't think we should try to take the 90% and make it 99%. We should take the 90%, try to make it 80%, because you get better compliance when you have professional legal assistance.
I'm not too sure about that. I see too many attorneys that fill out the form, hand it to the client, pushes them out the door, and that's the last that ever happens. I mean, that's the last they ever have.
Why doesn't you get perfect compliance?
Okay.
You get better.
That's why it's the 90, yeah, okay.
Yeah.
I have a few comments on this because this is the world I live in.
Yeah.
In the forms world and lots of pro se, more common law, but I don't like it. For example, we have an SLR in family law, probate. We have a form attached to the back of the SLR that needs something modified, and I can't modify it because I have to wait for the cycle.
Right.
Keeping forms out of statutes and rules, I think is better because you always have to modify them. There's always something wrong with them, and you can't. And so, if the state is doing better about providing statewide forms. So, doesn't mean that everyone's gonna use them, but we have our statewide website, and so Multnomah County, we built our website. I push everybody to statewide forms as much as possible if they're available. And then if we have to make our own separate forms, we just put them out there. So this could be the statewide form or something substantially like that.
Without being in the statute.
That's put on without being in the statute. I know in 2 years or in a year, we're gonna start struggling with this, and then I'll get an email from a lawyer that says this is wrong, or
Yeah.
whatever, and then I can't fix it, I can't do anything about it. So, and to change it is really hard.
That is a concern about statutory forms.
So,
And I said at the very beginning, when we started talking about a statutory form, that we were opposed to it.
and the pro se, they have not even a clue. They come to the counter and either the staff walks them through how to file this or not, or they're gonna use it, they're gonna love it. Forms, they love, having forms.
Well, how are they gonna love it? How's it gonna get to them?
It's available on the website, we'll have it in paper, hand out at the.
I mean, you would take this form and run with it?
Of course.
That's what happens now.
That's how it happens now.
I mean, why would you take this form as opposed to the forms you've got already?
Do we have one?
Yeah.
Whatever form that the state, I can't speak for the state form people, because I'm not them, but whatever form we adopt, then that's what we would go with. So I don't know whether it's even exact.
Yeah.
Almost all the small
And
counties.
we is who? We adopt. The state itself, OJD.
So there's a whole process within with OSCA where we produce forms. They're vetted by judges and a bunch of other people. There are several committees that work on them. And every time a statute's passed, we go back and we look at all the forms and see what changes have to be made.
Mhm.
We go through them and we get the forms put in place, hopefully before usually. 2017 was an exception because there's so many forms that had to be revised, but the FAPA forms, the ERPO forms, all that stuff has all been worked through several committees. And they're up on the website. Anybody can access them, and the courts use them all over the state.
And so do all the courts use the same forms, or do some courts?
When you go into the court's website, it takes them to the statewide forms. The link is immediately to the statewide forms, not to local forms. It's actually harder to find local court forms than the statewide forms for the public.
This is the best vehicle for
There
you
are
to use.
local forms though.
There are.
Depends, yes. Not every.
Yeah, because some courts may, produce forms like, for example, for minor guardianships. That's not a statewide form. A lot of the local courts have those.
Well, I guess that's the question. If you have a statewide form, if OJD puts a form on the website, can a circuit adopt its own variant of that form to an SLR?
It can, but it's actually harder for the public to locate it. It's not easy to find.
And they're
Because-
less likely to do it too, because they've got the statewide form.
But the question is, can the court require a different form? And the answer is yes.
Well, I liked your idea though of saying.
I don't know that they can. The statewide
We
forms
can put
are,
in there that somebody will develop the form and then that form works. That
all of
would
the
be
courts are
statute
under the
without
requirement.
having the whole
If
form
there's a
there.
statewide form, the courts have to accept them. They have to.
And you and I.
That's the way it
know,
stands right now.
Does that apply to county courts?
It's the best vehicle to get there.
No.
It's just.
Well, the county courts are kind of an obsession.
Well, I mean, the point is probate jurisdiction is vested in the county court in some counties.
Right.
So there's still gonna be, who knows what.
But if there's, all of us talk amongst ourselves in the courts, do you guys have a form for this? Because, I don't want to develop it. I don't want to develop form. So if it's there and it's pushed by the state, the chances, it's the best vehicle to get there. You can't force them, but it's the best vehicle to have uniformity. And we're finally moving that direction.
So if we were to not put this in a bill and adopt it as a form, first of all, you wouldn't include the initialing, or would you include the initialing? It doesn't have any legal effect. I guess it underscores the statement at the end that you've read it and and that every statement is true. Certainly the provisions about that Jennifer highlighted that would require amendment to the statute wouldn't be in the form because the statute isn't amended to require, but I'm not sure that we need death certificates to credit. I mean, that's, for instance, so if we were to just say here, what would likely happen?
I don't know, because that hasn't happened before, in my experience, where the courts have been handed a form to look at and to adopt possibly. But it was something that would have to go through the process.
Yeah, it would still, right, of course, it would still
A
go.
lot of hands and
Right.
eyes would be on it, so.
What about the debtor creditor stuff that came out last session they came up with a debtor creditor legislation and now there's the UTCR discussion about adopting it. Was that?
I don't know about that, sorry, I don't know.
UTCR is separate from.
Right,
So-
yeah, right.
So there was a debtor creditor bill that came out last session, and as a result, they're coming up with, what I've understood is you guys, and if I missed, please let me know, but you guys are really pushing this kind of TurboTax idea of form, so you can get people to have it easy for pro se. And that concept came from the bill, and they took that language, and now they're putting into this TurboTax form. And maybe I misspoke that it's a UTCR, and maybe it's a different process, but there is movement from legislative language, or they're attempting, my understanding, to a form online that is TurboTax-esque, that my opinion, you guys are excited about.
There are tons of those already.
Mhm.
I mean, they've been in place for a couple of years.
Yeah.
They're called guidance files.
Yeah.
And most of them are in the domestic relations.
Yeah.
So I could send you a letter and say, Brian, on behalf of the Oregon Law Commission, we commend this form to the courts for adoption. It comports with the recent amendments to the small estate affidavit and basically hand off to you. And and ultimately you'll do what the courts want, but we push it out to you as a form that reflects the amendments and the intent of the amendments.
How long does that take? Forever.
Well,
I can't
but
say.
remember, the amendments won't be effective until January 1 of 20. And you don't, the form isn't essential. I mean, the form's not essential. We don't have a form now, a statutory form. I mean, so, yeah, I mean, I'm just trying to find some way to use this, because first of all, I don't want to, again, I don't want to have be in a situation where we're asking the judiciary committees to arbitrate, a dispute between the courts and the work group, the law commission. That's awkward. But still get some utility out of Jennifer's work, in presenting this to you as a form that we commend to the courts, for due consideration.
What would be different with the uniform travel rule?
The people it goes through. And the UTCR committee only meets at certain times, and their timeframes, actually, a statewide form created through the courts would be much faster than going through the UTCR committee.
Really?
Yeah.
Because when we did the annual accounting, it was, I don't know, 6 months, a year, something like
But
that.
that's not a form. There's only a rule. But it's not an adopted statewide form. I'm talking about a form that goes up on the website that people can use. There's no such thing for the accounting. Because it would have to go through UTCR committee, they produce their rule and their type of form, and then the courts have to take that and work through it again, and so you're adding a layer to the process if you go through the UTCR committee.
Okay?
Most of them have their own version of the state form online right now.
Well, I used that form, that was the primary basis for this.
There's one thing I'll say to you, when we're talking about form, generally Judge McKnight, the language has to come way down. It needs to, like, instructions need to be about 6th grade level, or just throwing that out there. It's too complex, and I know sometimes.
Come up with a 6th grade word for escheat.
Well, and you can't take the
Right.
vocab, but you
Yeah.
still hold overall language.
Forfeit.
Forfeit, yeah. Turn over, give up. Okay. What about the instructions? Oh, okay, so, yeah. Can Jennifer participate in the court committee?
I'll have to ask.
Okay, yeah.
I don't see why not, but I'll have to ask. I'm not in charge of that, so.
That's great, you do a lot of work. So is there a probate committee on forms?
Not specifically on probate, no.
And that's my concern, is that you have these people on this committee who don't know probate. I mean,
That's been the problem through.
exactly.
Yeah,
That's
forever.
why you get all of this stuff out of the court that you're looking at going, what in the cat here is this? So if there's gonna be a committee, I think it needs to be people who actually know probate, as opposed to, I do domestic relations, therefore I'm gonna make this form.
In the cases where we've had a probate-specific form, they've deferred a lot to me.
They'll talk to him.
But there's a lot of other people in the state who know about probate.
Yeah.
Instead of putting all this on your shoulders.
Right.
You could convene us.
The brain trust.
The brain trust.
Going 6 years, man.
Yeah, right, yeah. Okay,
So can I make a couple comments? I think, first of all, I appreciate that Jennifer and Rita as well have put a lot of effort into this, and I don't want to see that effort wasted. I just don't want it to be mandatory. And I still think that you can take a lot of the non-informative stuff that's in this form, like Section 2, Section 3, the statutes apply, Section 4, that I can get an attorney, Section 5, about how this affidavit came about and all this, and take all this stuff about the responsibilities and take it all out of the pleading and put it into a document called an oath of office, that is just signed under penalties of perjury by the affiant, and have that filed along with the petition. That makes life a lot simpler for me. I prepare the petition, as I always have. They sign it. I give them this separate oath of office and say, here, this is what you're required to do. Sign it, and we file it.
but the oath of office, wouldn't that require statutory authority to?
Yeah, you can create that. I mean, there's another way to do it.
Yeah.
You know, I mean, it's just, it's just intermingling all of this personal responsibility with information stuff that makes this form so complex for a lawyer to get through with a client.
Well, and it sounds like there are issues with the language too, that the courts would
Yeah.
have even
Well,
with.
yeah, like you got to initial every blank. What do you do with optional, my email address is blank? Then, just on page one, then initial at least one that applies. Well, how do you initial at least one when you're required to initial them all?
Huh?
Well, you got to initial every blank, right?
No,
Bottom of page one, it says initial at least one that applies.
no,
So
there's
that's
that
not-
place that says you have to initial every blank.
Yeah, there is, if the one that the qualification to be a PR, you have to initial all, that you're not disqualified. I mean, that's one, but,
Yeah. I mean, those trivial, but, you
Like,
know,
stuff like if you look on page two, it specifies when you have to initial all.
right, oh yeah, there it is, right.
Because some of them, like under number 9, you may only have the
Right.
person died in that county, and so that used to be a checkbox, and then.
Right, no, I get it.
Yeah.
I have a lot of trouble,
Well, we know
explaining
you have trouble,
initialing,
John.
initialing instead of checking a box. People are accustomed to checking things, and
On the advanced directive, the initial, right?
yeah, so I had one obnoxious client who started.
One? Can I have your practice?
Oh, there's the only person I've ever done this.
You bring the best out
She
of
was,
us.
she was just such a terror. She started initialing the stuff, and I said, no, listen, you can't initial them, she said checking them. So you can't check them, you have to initial them. Why? Well, because that's the way the law reads, you have to initial them. So she says, she gives me a dirty look, and she checked and initialed every line after that.
Well, we need to amend the statute about that.
What is your initial?
That's right.
She initialed and checked.
Come on, initial. And then sign where you initial.
Yeah.
Okay.
Well, am I glad that's not my mother.
I am gathering the sense that we're not going to have a statutory form this session, but I don't want to leave this good work, just on the cutting room floor. So I guess, what would the group's feeling be, maybe if I do that, if I convey by letter the form to Brian, commending it from the commission as a form that we encourage the courts to evaluate and adapt and adopt as you know, as an appropriate form. Is that good enough?
Would that leave the courts around the state in a position where they could mandate the use of the form?
How does that work? When you adopt a statutory form, is it a required form, or is it a form that can be used?
No, it's not required.
Okay.
It's just like,
So that solves John's problem.
like a divorce.
Yeah, right, of course, yeah. So then you have the situation where maybe by default, we accomplish every pro se person uses this.
The vast majority. Yeah.
Huh?
No, they will.
The vast majority would.
Who can do this on their own? Without,
lot better than.
and they're begging for form, so.
It's a lot better than what, Jeff? Yeah.
I've seen some very creative pro se people.
Well,
You probably do.
Yeah, I do.
My question was, does your letter go to Brian or the chief?
Well, maybe to Martha then, yeah, maybe the chief, with a copy to Brian.
The Chief Justice.
Yeah, I think that would be the appropriate
You could just
entree, wouldn't it? Yeah.
address it to Brian, or the chief care of Brian, there you go.
Jennifer, how do you feel?
That's fine with me.
Okay. What about the, of course, we would excise from the form the new requirements, since those aren't in the statute. But that's just a few.
That would be, yeah.
That's just a few.
That are,
You highlighted them.
right, I believe that's right.
Yeah, and that was all about death certificates, wasn't it?
I think that was, and this actually was, a concern that, I think, was that concern, Rita, can you explain that concern?
Well, I think ultimately the death certificate and notification of the death certificate, we kind of switched the burden that because the limited form, I'm a creditor,
Mhm.
I don't know if you're John Smith
Yeah,
or John Smith.
right.
So I can ask the affiant, this switches it to allow the affiant, the creditor to say to the affiant, give me a copy of that, as opposed to the notification that the affiant is sending out the death certificate to everybody. So if I know full well that you're the decedent, you owe me this money, good, we're good to go. If I can't tell, then I get to ask the affiant for the death certificate, and the affiant has to provide it.
And that's because we used to have a social security number, and so then you would
Right.
know, this is that John Smith, and now we don't have that.
That's why we have to have
Right,
copies of the death
right.
certificate where we work, because
But,
we got 100 John Smiths in our data.
but does that defeat the purpose of making the death certificate a confidential record?
Well, I think the problem you're gonna run into with the death certificate copy, unless it's in statute, the vital statistics people are going to have a tizzy fit. Because in their mind, you aren't allowed to make a copy of the death certificate. And so that's, I mean, since it's in statute for us, where it says
Right.
you gotta provide a copy, that gives you the safety net there. But, if this is gonna be something promulgated by the courts, without statutory
Right.
authority,
Right.
I don't know whether you're gonna.
Well, that's what I said, I think without statutory authority, the death certificate would have to come out.
Yeah.
But my question is, if a creditor can get a death certificate on request, does that defeat the purpose of treating the?
I don't know, the creditors can.
Well, no, but if we were to change this, if we were to change the statute and the form, does that defeat the purpose of the death certificate being a confidential record?
Because my concern was that was raised, with regard to the court, I don't know if you're John Smith.
Right.
There's a confidential document, they're contacting the court saying, is this John Smith or John Smith? And that's the burden that, what happens there.
Yeah.
So that if, there's an acknowledgement and the affiant releases it, as opposed to kind of wholesale having it out there or having a public record. Because you take around the death certificates all the time.
Oh, you do.
So
Yeah.
if the claimant says, where is it? And you say, here you go, I don't know that that's defeating the purpose of having it confidential, because it's not a public record.
Right. Remind me why we took the social security number out of the affidavit, but,
Because we went out and used that issue.
yeah.
Another thing we could do is just put in the last 4 digits of the social.
And that usually works, yeah.
Ooh, that's good.
Then that would probably eliminate the problem.
That's elegant.
Yeah, for us, if we have date of birth in the last 4 words, we get a pretty high.
Oh, that's really elegant. That would be an amendment to 8888 to add that to the contents of the affidavit in the statute. Last 4 digits, I like that.
That's what's used in everything in all, if it's required, like the money wars, less work.
Okay, so that takes care of that. Yeah, let's do.
So the last 4 digits.
Uh-huh. In the affidavit, yeah. Oh, I like that. Okay, so then, Jennifer, so I guess then, can we have just a nod that, if we get, those, additions, removed from this, that we're comfortable in forwarding this to the courts as a form for them to consider in adoption of and that's all it is. We're not saying do it, and you can look at this and you can amend the language to bring it down to 6th grade, but this at least identifies the issues that we think are important in a statutory form. It's not a required form, so John can keep using his.
my guess is only a guess, is that they would appreciate all the work and the expertise put behind it.
Uh-huh.
And they would start here because,
Yeah,
at least, at very least,
A great starting point.
because no one wants to reinvent the wheel, and form building is not unique.
Right, right. Okay,
So that's-
yeah, that's my point. I don't want to lose the work that Jennifer
I don't think so.
and Judge Cobb have done. What about, okay, let's talk, we're just wrapping up here, so that's fine. This may be our last meeting unless we need to get together, after we all look one more time at the 3 drafts that'll be coming out. And that'll be focused just on those bills. Do we have, how do the instructions work with this? Would the court prepare its own instructions?
I would include the instructions with the form
Okay,
that you send them.
all right.
They will have a question because form, but
Yes.
they always do that.
Okay, does anybody have any comments on the instructions then, so that we get any work group input on the instructions?
One of the other people, and who was here, who, from US Bank, I think.
Oh, Linda.
Yeah.
She had a good idea that I just simply don't want to take the time doing, and that was to try to have the numbering of the instructions correlate
Oh.
with the numbers in the form.
Yeah.
And that would be very time consuming to kind of redo, so that.
That's,
It'd be fun too when you have gaps where your instructions jump from 9.
Oh, but no, but I think
IRS.
IRS, exactly, yeah, that's
that's
right.
exactly right.
It's the way the IRS instructions are. Line 1, this means, well, that'd be something the courts could do if they want to.
I do have one question about on the form on page 10.
Oh,
Where it says, I must file any required tax returns and pay from state property and taxes owed. That is not
oh, yeah,
clear in the statute. That is a duty that they have, and I feel like they really should know that. And maybe that would be moved to the instructions then. I could do that. I could move that to the instructions. If I'm trying
and that's, because that's a requirement of basically federal law.
Right, well, in Oregon.
Well, it is too, that's right,
Yeah.
yeah, of course.
And so, I mean, I could just move that to the instructions, trying to keep everything that's in here as statutory based.
Right, okay.
I can do that, I'll just do that.
I got another point for you to look at. I just happened to look at it. I think section 21 is confusing.
On
Page 6.
the form.
Yeah.
Well, before we go there, just the tax returns, if you've got the situation where you've got a trust and you're only doing the small estate to move that one asset that you left out of the trust as creditor bait or something like that into the trust, the trustee's still gonna file so it's not in all cases
Right.
a requirement of the claiming successor.
But it says you
Claimant
must file
successor.
any required tax return.
Well,
So if someone else, if you filed them as your role as a trustee, then.
yeah,
They're both required. They're both executors
yeah,
because they both have control of the deceased.
okay, all right, but,
Only if one of them does it, they don't both have to do it, but they're both obligated to do it.
right. Okay, but if we take that out of the form, then that solves that. So, well, I'm sorry, where were you going, John?
21. The consequences of missing heir are different than the consequences of missing devotee. So if you have a testate estate and a missing devotee, you can't check A or B, you have to check C. And then it's kind of confusing. If you're missing an heir and a testate estate, it doesn't affect, there's no escheat.
Oh, that's a good point, you're right.
Say that again?
I can fix that,
I was looking at the form, say it again?
If you've got, if you have a testate
Right,
estate
right.
and you cannot locate an heir or a devotee,
Oh, uh-huh,
then you cannot initial A, you cannot initial B, you have to initial C. And now it's confusing because if you have a missing heir, but the estate is testate, there will
right.
not be any escheat.
right, yeah.
But you're still gonna have to notify DSL that you have a missing heir. Because then DSL will step in and take over the interests of the missing heir.
Not in a testate estate.
Even in a testate estate, don't they? I'm pretty sure they do.
Whereas ESL could challenge the will?
No, I think as long as all of the devotees is there, those are the people who are gonna receive the property, and I don't.
Well, that's what he's saying.
Right.
Oh, and here, never mind,
Right.
never mind, right,
Yeah, right.
right. I got turned around, I'm sorry.
No, I can fix that, that's a good
Okay.
point, that, you're exactly right.
All right, well, good. Let's take a look at the instructions then. We got some time, and see if we can offer some comments to Jennifer. Yeah, the hard part about this is a lot of legal advice.
Lane, can I bring something up? I think we brought up before, this is Cleve.
Yeah.
On the issue of the confidentiality of the death certificate,
Yep.
is there some way to make it clear that that is applicable only to small estate filing? Because there are other statutes which provide for the recording of short form death certificates to establish
Oh, I
title
think
to
it is, I
real
think that is
property.
specific, because it's in 8888, the small estate, it's in our small estate affidavit, that the filing of the death certificate is a confidential record. So that really relates only to, let's see, where is the death certificate? It's in section 7. This is what you have to do. But Cleve, yeah, it is specific to a small estate of it, because you're right, you record death certificates all the time for real property purposes and vehicle transfers and things like that, or at least you use them.
It's section 7, paragraph 2.
Section 7, there it is, the affidavit, should follow a certified copy of the death certificate, as a confidential document, yeah. So that doesn't affect the use of death certificates for the deed records or anything like that.
Okay.
Oh, so we've got that in the small state statute.
Yep,
Okay. Section 7.
Yep, section 7, sub 2. So let's take a look at the instructions, for any guidance to Jennifer. Which will be guidance to the court.
And some of this was from the instructions
Uh-huh.
from Multnomah County.
Uh-huh.
And examples on like how things go according to the will or whatever.
So can I make an inconvenient comment?
Well,
You haven't dealt with a partial intestacy.
Right. Well, and some of this, I was wanting to, one of the things that these people need to realize, especially now that this is the fiduciary duty, is sometimes they just need to go. And so that's, some of this, if it's too complicated, consult a lawyer, because, your comment, Lane, that this is legal, like, yes, yes, it is.
The will doesn't,
Dispose
they have a
of all
will, but it doesn't dispose of all the
Like
assets.
a residue clause or something?
right,
Yeah, there's no residue clause,
right,
for example.
it happens.
And really,
Yeah.
that doesn't fit in for small states. There isn't a way in the small state affidavit to really address that. Is there?
Good question.
No, and we can't cover all.
I can write a form.
We can't cover all the complexities in the instructions.
Yeah.
In fact, these as they are, they're way too long.
Yeah.
They're attorneys who don't
Yeah.
Yeah.
Man,
I'm one of them.
Yeah.
But you're not a probate.
I never heard.
Well, and so I guess my thought is that this is really geared to the pro se person, and if there's something that they don't understand how to do, then they need to go to a lawyer. And it may be that they have a $1,200 asset, and it's gonna cost $1,200 to go to the lawyer, and okay, that's just the way it is, it's the cost of doing business.
I think the reality of a partially intestate is they're gonna fill out the form and say there's a will, and when they
I
get
get
to
everything.
where, yeah, they're gonna get to wherever it says. That's the way they do it. I've seen it. Yeah, we've definitely seen that. They're gonna get to line 20, and they're just gonna write out, the names of the people and the property that they receive, or they're gonna say the names and, 1/3 of everything, if it's 3 kids. And it's not gonna get into whether it is because the will
Right,
says that,
right.
or that's just what they think is what's right, and that's kind of just the process, though, and if any of those heirs or devotees has a beef with it, they should file
Right.
PSR, I guess.
Do you folks look at the will and see if what they've written as what goes to devotees is in the small state affidavit is accurate?
In the 2 counties we've worked in, yes.
In other counties, I'm sure not.
I'm
I've
sure
I've
not,
seen
but
the ones where they list 3 heirs and then identify only one to receive all the assets. But it's not a state of
Which is
state.
why we love death certificates, because we'll have somebody come and saying that they're the sole heir, and they'll say, what about the brother who was the informant?
Yesterday, $100, Mr. filing it. The death certificate says there's a brother, she's listed as the only heir. What about your brother? What brother?
Yeah.
And then, when we brought that up, it's like, well, he already knows he's getting nothing. And it was like, well.
All right, that's it, we're repealing small estates. That's it. The end of our work is no more small estates.
I said before that small states account for so much more course work.
Yeah.
Than the value.
Yes, I believe it.
Yeah, we spent 90 minutes with this woman who made us see 3 different occasions over this small estate. There was a $55 million estate 3 weeks ago that I have spent 0 extra time dealing with.
Yeah, that's right. Well, I'm sure there's good policy arguments for that, but that's not gonna happen, so.
When we're talking about things, I just want to throw out 2 words.
What?
Legal Zoom. You want to dismiss all this stuff, and you got all these people doing all this stuff on their own little.
Yeah, maybe we should send the form to legal.
And there's increasing.
Oh, absolutely.
amounts of crap documents.
Yeah, and the bar is looking at that and the future of the legal profession.
Yep.
Yeah. Well, it sounds to me that the instructions may be received a little bit more skeptically than the form. I guess the form would ultimately drive the instructions anyway, whatever is adopted as the form.
So how do we get progress on this?
Okay, no, I think here's what's gonna happen. I can see it all now. I'm standing on the mountaintop. Looking into the promised land, but damn, I'm gonna make it into the promised land. We have 3 LCs that we will send back out in proto-final form for everyone's review and give you a week or so to respond with issues, and then, Sandy and I can take a look at it, and determine if any of the issues you've raised, are, if we need to get back together to address any of them, one more time.
And if so, I'll reach out.
Yeah, right. So that's how we're gonna handle the 3 LCs. The statutory form, Jennifer is going to make some amendments to her draft statutory form. And then I will send that with a letter to, Justice Walters, commending it to the courts to consider in tandem with the amendment to the small estate statutes as something that the work group has reviewed. I won't say the work group has adopted, but that the work group has reviewed. And then the instructions is kind of where I'm still haven't decided what to do about the instructions. And maybe I just enclose them and say, and here are some instructions that you might want to look at too.
Yeah, well, the form refers to
Yeah.
instructions
Yeah.
repeatedly.
So I would.
That was part of what Rita and I decided was we want them to read the instructions, and a lot of it, some of the county forms had guidelines within the form. and I pretty much moved all of that into the instruction, so, they kind of go hand in hand.
So if I do this, Brian, will Justice Walters be on the phone to me as soon as she gets the letter and say, "What have you done?"
I have no idea.
Yeah.
I'm sorry, I don't know.
Maybe I should talk to her first.
But one other thing, just to make sure, on the bill, we're gonna add the last four digits of the social security number. Yeah. Okay, yeah.
So maybe rather than commend, maybe I'll say for your consideration. I mean, I'll talk to her. We're good friends. Yeah, I don't want to get crosswise with the court and just saying here, it's in your pocket now. Yeah. Okay. But I'll find some way to pass this on.
And we're gonna send the drafts out?
And the
I'll
three
get those
drafts,
out.
the 3 drafts will come back out.
I'll get them from Marissa and I'll send them out to the group.
You're asking about the bigger group, right?
Oh.
Send them to the section, or?
I think we decided we would wait until we're done with them. And send them out in edited form, in bill form. And frankly, that's gonna make it harder to amend at that point, but I really don't want to,
Can I send what we have to Warren Darris?
it is a free country, there is a First Amendment.
So we'll get 90% of the use.
I mean, right. There is a First Amendment that protects your right to,
He showed up in Multnomah one day with a marked up version of our form from Multnomah with all the changes we needed to make to it. It was really nice. I disagreed with him on 2 points, but the rest of it was great.
Yeah, he's totally anal.
he's got a lot of time on his hands too.
He does now.
Yeah, but that's fine. No, the Law Commission has not adopted the Governor's Office policy that drafts are confidential records. So yes, you may. So there you go. All right. Well, I think that, and we may see each other one more time if we need to address any amendments. But if not, I want to thank everybody for this. Frankly, there's still some work to be done on Chapter 111 that Jennifer and Heather have started, but we'll take a break. That work will be there. I mean, I guess my feeling is the system is working somehow, so it'll get by. And I don't think there's a strong desire in this group to go for another year.
So would we reconvene after the session to deal with those, that draft?
Or take a break for a year, or
I mean, I'm fine with what we've got now, but I think there are a lot of benefits by that particular statute, and I would really like to see us, that's getting some procedure out.
Right.
You know.
Okay. Well, let's you and me stay in touch on that, and see how we're all feeling after this.
I like the one you're off.
You like the one you're off? Yeah, maybe that's it.
Yeah.
Next year's a short session, maybe we reconvene after the short session next year.
Yeah, let's see if we got something we need to do.
Well, that's true. It'll give more time for some of these other things to come to light. All right.
And just one thing for everyone, what I'm gonna be working on is the OLC website to reflect what this group has done now. Now that so you'll start seeing things populated on the website, et cetera. If you have any questions about any of the work we've done, just contact me directly and I'll get you pieces as necessary.
So
Okay.
on the comments, will we be able to see the draft comments before those are presented?
I don't know.
Because I would really.
I understand. Yeah. We'll endeavor to make that happen.
So those will be presented with the bill?
They are,
Oh, okay,
but they're not approved by the work group.
right.
They're the reporter's comments. But
They're incorporated into the legislative history.
they do form the legislative history, that's right.
Okay.
But yeah, Susan's trying to get those out, at least in advance of getting to the legislature. Because I know you're concerned, you want to make sure that we touch the nuances.
Well, and Heather really wants to.
Yeah.
Yeah, and I took, every time she had mentioned something specifically, I took a note, but the meeting that Susan was not. Susan and I are gonna meet with the next couple of weeks to make sure that she's able to incorporate all of those into her comments specifically. And if there's anything from the past, Susan should have that.
Okay, so we'll do that. All right, I think that takes us to the end. Thanks, everybody. You'll be hearing from us.
What, no cake?
No cake.
I think there should be a more.
Oh, no, oh, wait, sorry about that.